Good afternoon, everybody. Thank you for joining me today to talk about anti-money laundering for schools, and in particular in the context of the Russian-Ukraine crisis and our sanctions regime. It's perhaps not the most colourful of topics, but I think an important one, and one which is topical, and judging by the numbers of you that are interested in this, obviously something you are thinking about. Hopefully we can cover off it's going to be at a fairly high level, I'm afraid, because there's quite a bit of detail to all of this, but we can talk in terms of key principles and give you some pointers. So we're going to break this down, and to start with, we're going to look at the identification of risk. So what is it we're actually concerned with? What are we trying to achieve here in terms of actually what are the relevant factors for schools to consider? Then we'll have a look at risk management. What does this look like in practice? What should you be doing, and how can you go about that? And then, of course, the whole purpose of having processes in place is that you identify when you might be dealing with a particular problem, and where you have issues, where you've identified that there is an issue, what are the implications of that for you in real terms? And we'll work through some specific questions that I think are likely to draw out some of the key considerations for you. And finally, there'll hopefully be an opportunity to ask and answer some questions as well. We'll see how the session goes and what I can get to in the time, but we can always look at those questions and circulate some answers afterwards if that's necessary. So without further ado, so in terms of financial crime, and that's really what we're talking about today, what do schools need to do to manage the risks of financial crime? I mean, schools are not part of the regulated anti-money laundering sector, and what I mean by that is that there are specific businesses that are named in relation to anti-money laundering regulations, where there are prescribed guidelines about how you go about assessing risk and carrying out due diligence. Now, independent schools for now are not part of the regulated sector. Businesses such as accountants, solicitors, estate agents are examples, and of course, businesses involved in financial services as well. But that doesn't mean that that this stuff is not relevant at all to schools. It is relevant. There are a number of pieces of legislation, and I've listed some, but not all, that create certain obligations and the potential for offences, criminal offences and civil liability to arise in relation to essentially the handling of money and the dealings that you have with parents, donors, and contractors and other partners. So there's some useful guidance here for you. It's by no means definitive, but in the context of what we're talking about, and we're going to spend some time today just looking at sanctions specifically, but there is a link here to the UK sanctions list, as well as the Office for the Implementation of Sanctions consolidated list. Some guidance as well produced by the Office for Financial Sanctions Implementation, which is really useful. There's both some general guidance and some more specific detailed guidance that I recommend you have a look at. And then Charities as well, for those schools joining us that are charities as well. There's some really useful guidance set out as part of the Charities toolkit that just deals with due diligence and monitoring and verifying the end use of charitable funds. So when we talk about risk, I mean, what in real terms are we actually talking about? What should schools be concerned about? So I've identified a few of what I think are the key risks. So you can have regulatory failings and civil liability. So I mentioned a moment ago that if you're a charity, there is some specific guidance and some specific duties. And of course, the Charity Commission as a regulatory body can intervene where it is concerned about how charities are conducting their business. Civil liability can attach as well. I mean, if you are a trustee or if you are a director of a company, you have got specific duties to your organisations. And where you fail to fulfil those duties because you expose it to too much risk, for example, you may have some individual civil liability to the organisation. And of course, there's the individual and corporate criminal offences, and these are things that really ought to strike some fear into the hearts of all of those dealing with money and risk management within your organisation. We'll have a look at a couple of those in particular, the ones that I think are likely to come up most regularly in a moment. And so, as well as looking at the sanctions regime, which I know will be of most interest to people, I'd like to just remind you of a couple of the other aspects of this topic, which I think sometimes can be lost in other priorities. Now, reputational damage, this is of course important for all schools. You know, you to some degree trade on your reputations, and you want to have a reputation for being responsible, but also not getting caught out. And we've seen some quite high profile pieces in newspapers, some exposés of international criminal gangs and the associations, unfortunately, of schools being named as having dealt with somebody that was later, for example, convicted of arms dealing, and those sorts of things can be very embarrassing, but more so, of course, if when you're asked to comment in advance of the publication of an article, you're not really able to point to a set of arrangements that are very rigorous in terms of who you're dealing with, and ensuring that your dealings are above board. So that's always worth putting quite high up the priorities lists. Financial loss. I mean, this goes without saying. If you don't have a proper sort of organizational risk assessment and processes that flow from that are effective in practice, you're putting your organization at a greater risk of financial loss. If it turns out that you are dealing with funds that are subject to some sort of criminal offence or investigation, you may find that that those funds can be frozen and clawed back. Of course, the risk of that you will suffer a fraud is greater where you don't have processes in place. And finally, there's the cash flow debt issue. You know, if you find that you are dealing with individuals who are caught up in criminal activity, for example, or are subject to sanctions, that could well have implications for their ability to pay and to move money as well. And of course, that applies to organisations who might be subject to sanctions as well. So just a little a note here about the nature of the duty on charity trustees as quoted by from the Charity Commission guidance. So charity trustees have a legal duty to take all necessary steps to protect their charities' funds and assets from misuse and to comply with the general law on fraud and financial crime, some of which I've highlighted. So trustees need to consider the risk of financial crime and manage those risks. So I think that passage is really clear in terms of quantifying this responsibility that actually trustees have individually. And I've mentioned failure to comply with those responsibilities exposes you to the potential for civil liability, as well as, of course, if you're involved directly in any dealings that turn out to be of a criminal nature, you may find that you are also subject to criminal sanctions as well. So charities will be aware that they have a responsibility to report serious incidents. This is a sort of reminder of what the test is. So, you know, loss of charities' money or assets, damage to charities' property, harm to work beneficiaries or reputation. So it's quite a broad scope really in terms of your reporting duty, but interestingly, and it's highlighted here, the most common types of incidents faced by charities are frauds, thefts, significant financial losses, and criminal breaches. And it's worth saying that because what you do about it as an organisation starts from assessing how significant a risk it is for you as an organisation. So this helps, I think, just to put some context there. Now, don't think if your school is not a charity that you that what I've just said doesn't apply to you. You're not subject to the Charity Commission's oversight as a regulator, but actually company directors do have statutory obligations in terms of their duty to promote company success, a duty to act with reasonable care, skill and diligence. And you could, again, there's a question of civil liability to your company if a director actually fails to comply with those duties. And bear in mind also Section 45 of the Criminal Finances Act, which created a corporate offence of failing to prevent tax evasion. And what this really did was create an obligation to have reasonable and proportionate processes in place in order to prevent you dealing with money that was tainted by tax evasion. And it applies in sort of various ways. But the point here is that just because you are a school that that is owned by a company rather than a charity doesn't mean that actually you don't have to have processes in place to deal with the risks of financial crime. Okay, so as I said, I just wanted to remind everybody of what I think are probably the most relevant criminal offences that you will be dealing with or concerned with as schools. And certainly when I'm looking at these two sections of the Proceeds of Crime Act, I'm thinking about your fees transactions, as well as, of course, your the donations that you would receive if you're a charity as well. Now, the first of these, under Section 328, is what I refer to really as the sort of general anti-money laundering provision. So this is where you would commit an offence if you enter into or become concerned in an arrangement which you know or suspect facilitates by whatever means the acquisition, retention, use or control of criminal property by or on behalf of another person. This is very widely drawn, so it's intended really to catch a huge range of dealings with individuals where those dealings are tainted by crime, almost of whatever nature. So an example of this might be if somebody has failed to pay the tax that was due and instead they choose to pay school fees. If you were aware that they were avoiding or rather evading tax, and that might have a criminal implication, and you accepted their payment for fees, you could be committing a Section 328 offence. So that's one example, but of many possible scenarios in which schools could find that there are risks for them here. And then there's the Section 329 offence, which is again perhaps broader still in terms of it being an offence if you acquire, use or have possession of criminal property. Now there is a defence here in that if you've received let's say money on account of school fees and then in exchange for services, that actually wouldn't be a criminal offence. However, that would you may well still be committing a Section 328 offence at the same time. And it is, of course, possible that if you're receiving donations for which you are not giving value back, then again, you could quite easily commit a Section 329 offence. And the relevant element here is that you would have to have some knowledge or suspicion that the individual that you are dealing with is in some way associated with criminal activity. So what do we mean by criminal property? And this is really just quantifying those two criminal offences. So it's criminal property if it constitutes a person's benefit from criminal conduct or whether it represents such a benefit. And the alleged offender knows or suspects that it constitutes or represents such a benefit. So again, there's an element of knowledge. But what's important here is that actually the definition of criminal property is incredibly wide. And in practice, what this means is that if somebody is making a payment, and I gave the example of somebody that hadn't paid their tax, then if they know that that was something that they were legally obliged to do, then the payment that they make to you would be tainted by that criminality. It would be criminal property, and that's where you would be dealing with Proceeds of Crime Act offences. So when we talk about money laundering, I mean, it means almost literally cleaning money. But I think it can conjure up ideas of very complex arrangements, and certainly there are some incredibly sophisticated money laundering arrangements out there. But it can be something as straightforward as a single act. So, for example, possessing the benefits of one's own crime. It may also be part of a complex and sophisticated scheme, and there may be sort of multiple methods of handling and transferring. And in very general terms, you're looking at a huge range of different transactions. And the key element really is that they are transactions that are in some way tainted by criminality. And I think that's the best way to think about it when you are looking at risk from your organization's perspective. And of course, one of the goals of the money launderer is not only to spend the proceeds of their crime, and that's certainly part of it. It can be about cleaning it so that it is seen as a legitimate source of funds, and that you perhaps are less likely to see that in a fees scenario, and donations perhaps are the higher risk area for that. But it's also about laundering reputations of people who are perhaps tainted by their involvement with it could be terrorist organizations, criminal organizations. And schools, I think, are really one aspect of the reputational cleansing by sending the offspring of a criminal gang member to a reputable English school. That does an awful lot to gain legitimacy. So schools are absolutely a target for individuals looking to launder their reputations as well as money, and it is worth bearing that in mind. Okay, now we come on to sanctions. And what do we mean when we talk about sanctions? I mean, everybody's heard the term now. Many of you will perhaps already be familiar with it. It's not a new concept, and you should have had procedures in place to identify individuals who are subject to sanctions, for some time now anyway. But it's worth just refreshing our minds as to what they are. So what are they? They can take many forms. So that somebody is subject to sanctions doesn't tell you very much, because they can be all sorts of different things. And from a school's perspective, I think what you will be interested in mostly will be individuals and organizations that are subject to asset freezes. That's where the problems, I think, are likely to arise for you. And for individuals, you'll most likely see asset freezes and travel restrictions as the sanctions, whereas there are a range of other types of sanctions that will limit the range of transactions that companies can enter into, and will have various other effects which we're not going to come on to too much today. We'll focus very much on the asset freeze. So who or what are they aimed at? And this really, again, is about helping you to set the scope of your management, if you will, of the risks around all of this. So when we're talking about the Russia-Ukraine crisis, then it would be individuals who benefit from or support Russian government in some way. So it's not necessarily the case that somebody who's subject to sanctions has done anything that's criminal, leaving aside, of course, the question of the potential war crimes being committed in Ukraine at the moment. And therefore, the Proceeds of Crime Act offences that we looked at won't necessarily apply, but there are a range of provisions that apply specifically to sanctions and the penalties that can apply when they're breached. But so you're thinking in terms of individuals who benefit from or support a particular government, and in this case, the Russian government. It could be a Russian government affiliated entity, so a business that's got some sort of links to the Russian government, or sectors of strategic importance. I've given the example of a few there, but there's many more. And of course, essentially, this is all about applying international political pressure to a country that is engaged in something that we've taken a political decision as a country to show disapproval of. So again, coming back to it isn't necessarily the case that the entities or individuals that are subject to these sanctions are involved in enterprises that are criminal in a more general sense. So who is bound by them? And this is where you come in, essentially. So um, everybody, essentially, all persons within the territory and territorial sea of the UK, and wherever they are in the world as well. So as organisations based in the UK, you must comply with the sanctions regulations. So as I said, we're looking at asset freezes in particular here, and what mustn't you do where you're aware of an asset freeze. So you mustn't deal with the frozen funds or economic resources belonging to or owned, held, or controlled by a designated person. A designated person means a person named under the sanctions regulations. Making funds or economic resources available directly or indirectly, and I'm going to pause for a moment on indirectly, to or for the benefit of a designated person. That's a very, very broad prohibition. So, for example, indirectly might be, so if you were to offer bursary funding to somebody who was designated, that would be making economic resources available to them indirectly. Engaging in actions that directly or indirectly circumvent the financial sanctions prohibitions. So with that one, again, it's drawn quite widely, and it's just worth bearing in mind what the objective is as far as the sanctions are concerned. It's really about boxing an individual into a corner, making it very difficult for them to enjoy the sorts of lifestyle and luxuries that they might be used to. And the idea being that ultimately that will lead them to bring pressure to bear on the government in question. So anything that you do that alleviates their difficulties in any way could well be a breach, a prohibited act. So it's absolutely worth taking some time to really digest those 3 points. Okay, so now we'll have a look at risk management. We've looked at what some of the risks actually are. So that's what you're trying to achieve, management of those specific issues. And how do you go about managing it? Well, you manage it in the same way as you manage any risk. You start with a risk assessment for your organization, and really you need to be looking at the full range of your dealings. So we think immediately about parents and fee payers that may be caught up in the sanctions regime, but actually also think about, of course, donors where you're a charity, but partners, contractors, suppliers. There are implications around all of them, and associated third parties to the extent that you're aware of them and able to ascertain them. So once you've got an organisational risk assessment, you know what the risks are for you and where they'll be coming from, then really it's about managing those with reasonable and proportionate procedures. You are entitled to take a risk-based approach. So there isn't one set of rules that apply to all schools. Some of you will have an international intake, and there may well be additional risks for you around that, and others of you may have other marketplaces that raise the risk profile. So it's very much about doing what is reasonable and proportionate in response to the particular risks faced by you. Now, I've set out a few bullets here in terms of what I think a reasonable and proportionate procedure is likely to cover in almost any case. And it's really then a question of the degree to which you go through these various aspects. So the first point, and this really is the absolute central principle here, which is know who you're dealing with and why. I mean, it sounds ridiculous because, of course, why would you be dealing with anybody if you didn't know what it was that you were doing with them? But actually, it just means in a very literal way, ensuring that actually you do understand, the involvement of individuals. And a very straightforward example will be if you have an applicant for a pupil to join you, and there is there is somebody proposing to pay the fees who doesn't appear to be an immediate carer or relative of that individual. Now, there may be perfectly legitimate reasons why they're proposing that arrangement, but actually knowing who they are and actually why it is that it is them taking a lead on that is of course going to be important. Next element of this is risk-based due diligence. So, as I've said, how far you go depends on the extent of the risks for you as an organisation. But due diligence just really means the questions you ask, the research you undertake in order to ascertain the full extent of who you're dealing with, the extent to which not only do you ask who somebody is, what their name is, you actually seek to verify that too. And you might ask for passports or other identification information, so dates of birth, in situations where you felt that that was justified based on the risk. You'll absolutely want to have some sort of provision for ongoing monitoring, because it's all very well thinking about all of these things when you take somebody on for the first time you enter into a relationship with a contractor supplier, first time you enter into a relationship with parents, but actually making sure that there is some ability to keep an eye on your dealings and any changes that occur along the way to ensure that the risk doesn't change is going to be vital. And reporting. What's the point of having all of these arrangements if when you identify a risk, you don't do anything with it? So you need to understand when you have to report and actually have some provision to do that. And so I've mentioned there, you may have a reporting obligation to the Office for Financial Sanctions Implementation, where you think that a breach of sanctions may have occurred, to the National Crime Agency, where you think that you might be dealing with the proceeds of crime, and to action fraud if you suspect that a fraud has taken place. So having designated roles is going to be really important, because again, that makes sure that your processes actually can be effective in practice as well. So you may want a particular individual to be responsible for reporting, and they can therefore be the hub for reports from staff members more broadly. Training, absolutely vital. There's no point having a process procedure without actually helping staff to understand what that is and how to apply it in practice. And of course, also keeping it under review. Things change all the time. The sanctions regime is really fast moving. And certainly so long as the Russia-Ukraine crisis continues, we can expect further sanctions. So staying on top of those is a really good idea, and making sure that your procedures remain fit for purpose is always prudent. Okay, so I've suggested here some risk factors for you, and these are by no means exhaustive. And I think again, it's really useful when you're undertaking your risk assessment as an organisation to come up with your own list really of risk factors. But here's some which I think could perhaps be of general application. So unusually secretive behaviour. If somebody doesn't want to tell you very much about who they are, what they do, where they get their money from, for example, that it may it's certainly a risk factor, and it's something that would suggest to me that there's some further due diligence needed to reach a point of satisfaction. And I like to think really about this in terms of it's what is used. I mean, in the regulated anti-money laundering sector, we tend to refer to the smell test. If something doesn't seem quite right, it makes you feel uneasy, then what's the obligation? The obligation is usually to ask such questions or to do such research as to get to a point of comfort. And that's just a sort of quite earthy way to think about actually what all of this means in practice. So payments of big cash payments, I mean, everybody knows cash is higher risk. And it evokes that very real representation of money laundering as the sort of the used banknotes going into some sort of a machine and coming out shiny. But of course, most of you, I think, will already have policies in place that limit the cash receipts, if not prohibit them altogether. But absolutely, that's prudent. Doubts about the individuals that you're dealing with or where they are, of course, those are risk factors. Involvement of third parties without logical reasons or explanations. Now, this comes up in terms of fees and donations quite regularly. It may be that you could be talking about third party companies, trusts, other organizations, and really understanding who they are and what they have to do with the school, or what their reasons are for wanting to make payments or become involved in some way with you, I think is going to be really important. Overpayments for no good reason. Certainly, I've already been made aware of a number of schools dealing with individuals who might be Russian nationals who want to make large payments in advance. Now, there may well be good reasons for that, but if those reasons haven't been given, that should be regarded as a risk factor, and certainly a prompt to have a further conversation. Doubtful source of the funds. I mean, this comes really back to the extent to which you set your sort of due diligence measures in the first instance. Do you always have a way of capturing what it is that your parents and donors do? What businesses they're involved with, and so that you can make that sort of common sense connection between their ability to fund the fees and or donations with what they do. Cancellation reversals or requests for refunds. I mean, anything that's out of the blue as far as financial transactions are concerned, it's always worth applying a critical eye. Again, there are often really good explanations. I think the key is about making sure that you have those explanations, you understand what is going on there. And conditional donations. I mean, I think, again, there could be perfectly good reasons why somebody would place conditions upon accepting a donation, but unless you understand what those reasons are, then those should be regarded as a risk factor and requiring you to take a few more steps to get comfortable. So when we talk about due diligence, I mean, here are just some of the kind of key aspects. I mean, if you were just setting up a process from scratch, here are some of the things I think that you'd want to be thinking about in terms of your due diligence. So geographical location. Now, this is relevant because there are certain jurisdictions that do not manage financial crime as robustly as others. There are some which are institutionally corrupt, for example, and the Financial Action Task Force keeps a register actually of higher risk jurisdictions. So it's really worth always checking that and seeing whether your proposed dealings are with individuals or organizations based in those jurisdictions, because certainly that's going to place the risk a little higher. And I think therefore would call for you to do a little more to satisfy your due diligence requirements. Now, politically exposed people, again, this is something that's quite straightforward to ascertain. Actually, some desktop research usually is all that's required. But of course, there are also lots of third-party organizations now where you can outsource this type of due diligence. Now, what you're thinking about in terms of politically exposed individuals are individuals that have some, sort of connection to states, or are in some other ways bound up in sort of public life. And so they are higher risk in terms of their involvement potentially with terrorism or bribery and corruption, those sorts of things. So you need to identify if you're dealing with a politically exposed person and make sure that you're satisfied about the nature of the dealings that you're having with them. Sanctioned or proscribed organisations. So keep an eye on all the government lists, and I've given you the links to the UK and consolidated lists for sanctions. There's also a government list for organisations that are proscribed, and what this means is that they are identified as terrorists, and therefore it is prohibited to have any dealings with those organisations. So identification is, of course, the first step in managing the risk. And third parties as well. I mean, I've mentioned this as a risk factor, but I think straight away, if you're dealing with individuals that are organizations, rather, if you're dealing with organizations rather than individuals, I mean, particularly in the context of fee payment, it is good to approach those arrangements with a critical eye, because there are good reasons to involve third-party companies and trusts. but there are also reasons that are potentially problematic as well. So understanding the nature of those arrangements, and actually I would recommend you have additional contractual arrangements to regularize those relationships, certainly in the for the purposes of fee payment. So a third party agreement, I think, is a really sensible way to manage the risk. Okay, so I mean, this is certainly not exhaustive in any way, but I think where you have got your processes in place, you've done your due diligence, possibly identified some risks. Let's look at the question, I think, of parents and fee payment, because after all, today's session is really about the sanctions. So I want to have a look at actually what the practical implications are if you're dealing with an individual who's subject to sanctions. So I think these are some of the critical considerations. Are you dealing with existing or prospective pupils? What sort of fees and other dealings are you proposing to have with that individual, or have you already had? Do you need to have? And of course, I'm thinking in terms of refunding deposits, for example, and the contractual rights and obligations. I mean, get into the detail of your parent contract. If you find you're dealing with somebody that is subject to sanctions, actually, what are the contractual rights of the parties involved? If think about fees payments, but also think about whether you have to go on providing services and how you might bring that relationship to an end otherwise. And finally, don't forget the Equality Act. So sanctions are a political measure that are taken with regards to individuals from a specific jurisdiction. When we're talking about Russia, Ukraine, we're talking about Russian nationals that are subject to individual sanctions and asset freezes in particular that we're focusing on. And so if as a school you were to say, well, we don't like the thought that we would be at risk of dealing with anybody that might be somehow directly or indirectly associated with the sanctions, we're just going to have a complete ban on Russian applicants, then actually that's likely to be problematic under the Equality Act. Race, nationality is a protected characteristic, and you would need to ensure that your processes are a proportionate means of achieving a legitimate aim in order for those to be lawful. So we're just going to work through some specific questions now, and this is really by way of applying what we've covered so far. So can you refuse new applications based on nationality? Now, I've alluded to this already. So the answer is yes, you could, provided that was a proportionate means of achieving a legitimate aim. Now, simply to say nationality with no other criteria is likely to be too broad, because whilst you may well have legitimate aims, which are to manage financial risk and the risk in particular of breaching the sanctions regime, it wouldn't satisfy the proportionality test, because just having a blanket refusal to accept new applications from a particular nationality casts the net too wide. So it may be that you could include nationality as a factor subject to a qualification about the types of steps that you could take. So I would suggest, for example, it would be lawful to ask more questions of a Russian applicant than it would regarding somebody from France, for example, because of those greater risks. Whereas if you just simply said you're a Russian applicant, so no, that's likely to be unlawful under the Equality Act. So is a family's nationality a risk factor? I've already said the answer to this is potentially it is. So that doesn't mean that anybody that isn't based in our jurisdiction is higher risk. As I've already pointed to the Financial Action Task Force register, which identifies higher risk jurisdictions. If you've got a family applying from one of those jurisdictions, then absolutely that's a risk factor. And of course, when we're talking about sanctions, thinking about the types of nationals that are subject to those sanctions, again, those are absolutely risk factors, and that's important because what that does is it sets the bar for the due diligence that you carry out. You should be doing more where you identify those risks to identify and verify. If you get a sanctions match or you suspect criminal activity or connections, what should you do next? This is the sort of this is the crucial question, I think, isn't it? So let's just break those down. So let's start with the sanctions match. I'm just going to keep an eye on the time because I'd like to have some time to answer some questions. But if you get a sanctions match, going back to what I said about the incredibly broad nature of the prohibitions, you cannot deal with funds that have originated from somebody that is subject to sanctions, or an organization that's subject to sanctions. So what you need to do is pause, essentially do nothing other than you need to report to the Office for Financial Sanctions Implementation. Now, when you do that, they may well give you some sort of guidance as to what you can do next, but at the same time, you need to be thinking in terms of whether you can apply for a license to deal with that money. So I'll give you an example. If you've been dealing with a family for a long time, the pupil's about to leave you, all that's left to do is simply to refund a deposit, and you find out actually that the parent, one of the parents, is subject to an asset freeze, then you may you may be able to refund that deposit under some pre-existing exceptions to the sanctions regime. But having said that, those are drafted in quite narrow terms, and I think in these circumstances you would want to apply for a license from the Office for Financial Sanctions Implementation to be able to refund that deposit, or perhaps to continue to accept money. But I think the OFSI is likely to think very carefully about when the grounds for issuing a license are met, because it would actually really like to know that actually those individuals that are subject to sanctions are put to considerable inconvenience, and I suspect that they're not going to have very much time for the idea that they will be continuing that person's child's education, if that's a luxury that they've got used to having. But you need to take that step in order to do anything more, because otherwise, just by simply refunding a deposit, you may well be breaching the sanctions, and that can expose you to fines as well as imprisonment in some cases. Now, the same thing is true if you suspect criminal activity as well. So again, this might be if a parent has made a joke about avoiding some tax, for example, and makes a payment. So I'm going to continue with that example to you for fees. What would you do in that case? You know, anything you do, you can't just return the payment to the parent because you're dealing with those funds. That's likely to be caught by one of the offences. So in those instances, you would make a suspicious activity report to the National Crime Agency, and you would ask for a defence for any of the relevant proceeds of crime act offences to be able to deal with those funds in the way that you need to do so. And until you've had a response from the NCA, you shouldn't do anything with those funds, and that can of course put you in quite a difficult spot with your parents if they're asking questions about why it is that the school's not doing anything. But actually you have to be really, really careful, because anything you say that actually then prejudices some sort of an investigation can also be a criminal offence. So it's difficult, and it would be a case of seeking the guidance and saying what you had to say to the parents to try and put them off in the meantime. Can you return doubtful payments? I mean, this really sort of comes into question 3. So you can't, or at least it would be a considerable risk simply to return a doubtful payment. It depends on the basis of doubt that you have. So if you're not dealing with a a suspicion that somebody is sanctioned. So something that's tangible rather than just a sort of general sense of unease, then you might be able to return that payment. But I think if you've got any basis for feeling doubtful about that payment, then it is best to think in terms of, are there specific reports that you need to be making in order to put you in a position to do something with that money? And whether that's in the context of sanctions, the Office for Financial Sanctions Implementation, or the National Crime Agency, as we've mentioned, then you need to follow that route. And finally, can you end the parent contract? So you may be in a position where if one of your parents is subject to an asset freeze, I mean, is likely to be for some time, that you're not going to get paid. And unless there is some alternative source, well, in fact, in that situation, even where there's an alternative source of funding, you may be providing a sort of an economic benefit to that individual. So I think really you are probably in a position where you are not able to get paid, where you're dealing with the offspring of someone subject to a direct sanction. And so you're not going to want to continue that arrangement. You can't apply any sort of credit bursary funding in order to plug the gap, because that has the same problem. And so what do you do? Most of you will have non-payment provisions under your contract that would entitle you to exclude and to bring the contract to an end. So those may well offer a way forward. You may also have other mechanisms within your contract that would permit you to give notice for, let's say, reasonable cause. And it may even be that you've got termination provisions that hang on something, let's say, bringing the school into disrepute. So dealing with an individual that is subject to sanctions might suffice in that case. So it's just really important to actually look at your parent contract, identify the most appropriate route, and to deal with that. Right, okay, so we've got 9 minutes left, and I would just like to get into some of the questions, if I may. Okay, so somebody's asked, in terms of sanctions, how far do you need to look through? Is an in or out of sanctions list sufficient, or is deeper due diligence required? So, I mean, really, this comes back to the sort of the reasonable and proportionate. You know, if you are a school that doesn't have dealings with Russian families in general, then actually a sort of a check of the sanctions lists is probably going to be enough. But do bear in mind that the sanctions lists include aliases as well. And so many of the individuals that are subject to sanctions go by a number of names. So you just need to make sure that you're able to identify in a meaningful way the information that is on those sanctions lists. And if you have, if you've taken at face value that you're dealing with somebody of a particular name and you haven't taken steps to verify that person's identity, then it's difficult to see how you could be completely satisfied purely by looking at the sanctions list that you're not dealing with somebody that is subject to sanctions. So I think in those cases, you might want to take a view that anybody who might be of Russian origin, for example, you might want to think about whether you take additional steps to verify their identity, even if that you have an ongoing relationship with that person, rather than this being an application. So what if governors want to refuse Russians on moral grounds in support of Ukraine? So this is, of course, a sentiment that I think everyone understands. There's been a huge outpouring nationally and internationally of sympathy for what's going on in Ukraine and at this moment. So entirely understandable. But of course, it's very difficult, isn't it, to attribute motive to individual members of a particular population. And of course, we've also seen that there are protests going on in Russia that obviously are clamped down on quite quickly. But I think simply to have a blanket policy where you refused Russian applications, as I've said before, is likely to be a breach of the Equality Act, so not lawful. So yes, I think that's probably the answer to that question. Right, okay, so what if a Russian parent is asking for a deposit to be returned to their UK account, even though it came from overseas? They're saying that they no longer bank in Russia. So, I mean, in this situation, you've got a couple of risk flags here, haven't you? You know, it's a Russian parent, and we're talking about a higher degree of risk at the moment, particularly as you're being asked to do something that is not entirely regular, which is by refunding a payment to a different bank account from where it originated, and particularly refunding it to a UK bank as opposed to the overseas origin of the payment. So what do you need to do when there are greater risks? You need to investigate further why the parent is requesting that you do this, and get to a point of being satisfied that there is a legitimate reason to do that. So there isn't, if you've checked your sanctions lists and this individual isn't subject to sanctions, there isn't anything necessarily unlawful about agreeing to do what they're asking of you. And again, if they're not associated with criminal activity in any way and you don't suspect they are, then it may be perfectly lawful to do this. But I think asking the question and being satisfied with the answer is the key thing in that scenario. So what if the person you're dealing with is not on the sanctions list but related? So at the moment, there's a test essentially in the Policing and Crime Act around sanctions implementation that says if you don't suspect or know that what you're doing would be a breach of sanctions, then that isn't going to be a breach. Now that's going to change, because actually the Economic and Crime Act, which came in recently but isn't fully in force, is going to make this a strict liability offence. So what that means in practice is that you're going to need to go a bit further. So yes, absolutely check the sanctions list. You need to cross-check that with some broader research to make sure that the individual you're dealing with doesn't have aliases or isn't connected. If you establish that there is a connection, then again, you need to be really cautious about dealing with that individual, because the connection may be sufficient to render any transaction a breach of the sanctions, and it's better to take the cautious approach so that you are reporting to the OFSI and seeking a license where necessary to do anything that you need to do. So if a parent uses a bank that's been sanctioned, can you seek alternative method of payment? So absolutely, you can. So if a parent is using a sanctioned bank, that doesn't mean that the parent is engaged in anything untoward. It doesn't mean that they themselves are subject to sanctions. And if they've got another bank account and they're able to make the payment elsewhere, then of course that should be perfectly okay. I would suggest, however, that anybody that is caught by the sanctions directly or indirectly, you just take a little bit of additional time to check that that actually they've been inadvertently caught up in it rather than are in any way associated and subject to those sanctions. Just check. So we've still got a few minutes. So at what point would you advise starting to look into parents during the admissions process before an offer is made? How would you suggest doing this to avoid discrimination? So, I mean, this really, I suppose, is perhaps a question as much about practicalities as anything else. If you were to have due diligence, quite extended due diligence at the point of application, you're going to be doing an awful lot of work. Now, it might be that you have arrangements with third parties that make that easier, but there'll be a cost implication for that. So really, it's about identifying perhaps the point in the process that is going to be most practical for you. And there isn't a perfect answer, because of course doing it a little bit later on is going to have practical implications as well. But I would have thought that most of you would come to the decision that actually doing those types of checks just before offers are made, once you've identified the short list, if you like, of people you'd like to make the offers to, is probably the best time to do that. It will balance the amount of work to be done with obviously ensuring that you're undertaking effective processes. Okay, it took the UK government 2 weeks to sanction Roman Abramovich, arguably the highest profile Russian in the world. What happens if a parent's placed on the sanctions list in 1 month's time, having paid for the summer term fees? So you'll only breach the sanctions once they've been applied, in short. So from a perspective of assessing the risk of dealing with a family and an individual, there are certain high profile individuals, Roman Abramovich being a good example, where it was entirely foreseeable that he would end up subject to sanctions. That may not be the case in many instances, and the transactions that you have with those individuals right up until the point they're subject to the sanctions are going to be entirely lawful and legitimate. So that won't be a problem. What would be a problem, of course, is what you do next, and we've looked at that in a little bit of detail. So where can sanctions lists be found? I included the guidance actually at the beginning of the slides, which will be circulated after this session. So there's the UK sanctions list, and then there's the Office for Financial Sanctions Implementation consolidated lists. And you can also sign up for the OFSI's alerts, which I would recommend, because then you'll get that sort of up to date as it happens bulletins about who is subject to sanctions and when the lists have been updated. So let me just have a look. I think there are a couple. So to what extent are we entitled to rely on the AML actions checks of others? So I'm thinking specifically of UK banks. If we insist, as we do, that fees must be paid from a UK account, how much can we rely on that? So I mean, the answer to this is, as far as sanctions specifically are concerned, it won't be a defence to say that that we've relied on the due diligence of the UK banks, and we've insisted all parents and donors pay via those banks. So you still need to do those checks yourself. But of course, if you had processes, if you had policies and contracts that require those banks to actually process those transactions, it's going to reduce the risk hugely anyway, because of course the obligations on those institutions are greater than the obligations on schools. So it's a good way to reduce risk. What it doesn't do is it doesn't let you off the hook if it turns out that you're dealing with somebody who is sanctioned. If the bank's missed it and you end up taking a payment, then once it is a strict liability offence, you will still be responsible. So you do need to just make sure that you are taking your own steps to understand who you're dealing with and whether they're subject to sanctions or involved in anything that might be criminal.